By the order of the Board of Trustees of St. Peter's Church, and my colleague, Mr. Riker, from the examination he had given to the cause, had become convinced that an exemption for Father Coleman was legal. The next morning,
may it please the court. If in the discussion of the present question I should discover more than ordinary solicitude, a sufficient apology, I trust, will be found in the novelty and the magnitude of the cause. On the one hand, the exemption claimed by the Reverend Pastor is now, for the first time in this country, brought judicially under examination. And on the other, every enlightened and pious Catholic considers the free toleration of his religion to be involved in the decision that shall be made in this case. Under these considerations, we respectfully ask of the court a patient and dispassionate hearing, and we fully expect to satisfy Your Honor that the law and the Constitution are on our side. There are but 2 cases to be found on the books in which a minister of the gospel has been called upon to testify what had been communicated to him by a penitent. One was the case of one Sparks, a Catholic who made a confession to a Protestant clergyman and who was tried before a Mr. Justice Buller. Of the decision of the court in that case, Lord Kenyon, the Chief Justice of England himself, remarked, "I should have paused before I admitted the evidence there admitted." Also allow me to call to the attention of the court the only remaining case, Butler versus Moore. It was decided in Ireland in 1802 before Sir Michael Smith, Master of the Rolls. That case concerned the estates of the late Lord Dunboyne. His will was contested. The plaintiff alleged that it was invalid because Dunboyne, on his deathbed, had relapsed into the Church of Rome, which, under the Irish penal laws, still deprived Catholics of the power to make a will. The Reverend Mr. Gahan, a Catholic priest, was called upon as a witness and asked, what religion did the late Lord Dunboyne profess from the year 1783 to the year 1792? Father Gahan answered, Protestant. But when he was asked what religion did he profess at the time of his death and a short time before his death, Father Gahan refused to answer on the grounds that the information was confidential. He said his knowledge arose from a communication made to him in the exercise of his clerical functions, which the principles of his religion forbid him to declare, nor was he bound by the law of the land to answer. The judge disagreed, saying Father Gahan was not specially exempted and protected by the law because no special exemption could be shown. He cited the decision of a single magistrate. Upon this adjudication, I need only observe that it was made in a country, Ireland, remarkable for the religious intolerance and bigotry of its laws. Precedents in such a country and in such cases ought to be admitted by us as authority with the most scrupulous caution. Now, it will not be denied on our part that the general rule is that every person is bound, when called upon in a court of justice, to testify whatever he may know touching upon the matter in issue, nor will the Attorney General deny and dispute that there are exceptions to this general rule, some of which are contemporary with the law itself. I trust, to the satisfaction of your honors, that this court is at perfect liberty in the judgment that it shall finally pronounce in this cause to follow the guidance of liberality and wisdom unfettered by authority. I shall now proceed to examine the first proposition which I undertook to maintain, that is, that the 38th article of the New York State Constitution protects the Reverend Pastor in the exemption, which he claims independent of every other consideration. Religious liberty was the great object which they had in view. They felt that it was the right of every human being to worship God according to the dictates of his own conscience. Again, the Catholic religion is an ancient religion. It has existed for 18 centuries. The sacrament of penance has existed with it. We cannot, in legal decorum, suppose the convention to have been ignorant of that fact. The great body of the American people are Protestant. Yet, our Catholic brethren have never hesitated to take up the sword with us and to stand by us in our hour of danger. The father of this country, the illustrious conductor of the Revolution, George Washington, did not hesitate in the face of the nation to do justice to their revolutionary services, to their good conduct as citizens, and to the aid which they rendered us in the establishment of our free government. Your Honor, I confess, I feel a deep interest in this cause. I am anxious that the decision of the court will be marked with liberality and wisdom. I consider this to be a contest between toleration and persecution, a contest involving the rights of conscience. To compel the Reverend Pastor to answer or to be imprisoned must either force his conscience or lead to persecution. I can conceive of nothing more barbarous, more cruel, or more unjust than such an alternative. To compel him to answer against his religious faith or to confine his person would be the highest violation of right that I have ever witnessed. It would cast a shade upon the jurisprudence of our country. The virtuous, the wise of all nations would grieve that America should have so forgotten herself. There is nothing, certainly, more unreasonable, more inconsistent with the rights of human nature, more contrary to the spirit and precepts of the Christian religion, more unjust than persecution.
Too right. Mr. Riker had shown, by reason and authority, that no rigid rule of evidence can stand in the way of justice and convenience so as to bear the exemption we lay claim to. That these rules are the handmaids, not the tyrants of a court of justice. And that when new cases occur within like reason as former ones, the same principles will govern them. And that the door of justice and propriety is never closed. The Council did not, however, rely entirely upon general reasoning, but showed the current of authority to be so strong that our ingenuous adversary, Mr. Gardiner, at the request offered by St. Peter's Church, was compelled to evade it, and driven to maneuver with what dexterity he could in the countercurrent and eddy of popular prejudices. After a recess, Mr. Gardiner began his rebuttal by saying that he had, with great reluctance, contested to bring up the present question for discussion.
For it is not so much public importance that the offense charged against the accused, the receiving of stolen goods, should be punished, as that the repose of a respectable religious sect should remain undisturbed. I hope I would have given offense to none. It is a question delicate and tender in its nature. My duty now has compelled me to proceed and to examine whether the priests of the Roman Catholic Church are indeed entitled to a privilege to which no other persons are allowed. That of concealing their knowledge of matters that concern the public good and the public safety. I propose we examine this question on the basis of the common law and of the Constitution. First, the common law. Under the general rule, the priest is obliged, in common with every other member of a community, to answer. There is no case in which he was ever exempted, and every case that has been decided or agitated in relation to this point is in support of the general rule. At common law, therefore, the priest has no privilege. It remains to inquire, therefore, does the Constitution of New York State give this privilege in this particular case? The People versus Phillips? Secondly, the citizens of the state of New York were a Christian Protestant people when they drew up their Constitution back in 1777, but aware of the injustice and evils of religious intolerance, they wisely and magnanimously resolved that not only sections of the great Protestant church should be equal with each other, but that persons of other religions should also be equal to them. But it was never intended that any one should be superior to any other. To tolerate religious profession and worship is one thing. To allow any person to conceal matters upon which the knowledge of the public safety may depend is, well, it's another. Your Honor, it is palpable that the pretension here set up is inconsistent with the safety and the rights of society. If the Reverend Coleman remains silent, crime remains unpunished. Can society endanger its safety by yielding to such a claim? Can it be supposed that the representatives of a Protestant people intended to be so very tolerating as to deny Roman Catholic priests even the right of saving the state? It would have been a suicidal act. Suppose a Roman Catholic priest knows the actors in a treasonable conspiracy. Suppose. To deliver our city to the enemy? And if the persons can be known, the plot may be defeated. Shall he be permitted to say, my religion forbids me from preventing the horrible effusion of blood which must follow, for my knowledge is gained in confession? But confession is a sacrament. How can secrecy be a part of that sacrament? Upon what principle is it that Quakers refusing to bear arms are compelled to pay a fine or commutation? What is the Quaker's offense? That he refuses to yield his personal services for the protection of the Commonwealth? Why does he refuse? Because the Word of God does, in his judgment, forbid man to shed man's blood. The excuse is not received. His personal services are indeed dispensed with, but he is made to pay. Political lawyers, right, can never acknowledge a principle in society which excuses any individual from the duty of protecting society. The practice of every state has established the principle that the safety of the state being the first duty, the Quaker shall pay a fine as a punishment for omitting to do what his religion forbids. Why then shall the Roman priest be excused from the same great duty? Why shall society allow him to omit doing that which is essential to its safety? I do not deny that the penitent has a right to confess. Let him confess. He is not punished for that, but for his crime. The privilege claimed by the Catholic penitent in this case is not that he may ease his conscience by confession, but that confession shall never rise up against him. The privilege claimed by the priest is not that he shall be allowed to hear, but that he shall be forbidden to tell. By the Constitution, there shall neither be discrimination nor preference. Now, what a Protestant layman should confess to a Protestant minister, that minister would be compelled to disclose. The Catholic, not. Is not here, then, a discrimination, a preference, not only forbidden by the Constitution, but dangerous to all sects that compose the society. The Constitution has granted religious profession and worship without discrimination or preference to all denominations. But it has not granted exemption from previous legal duties. It has expelled the demon of persecution from our land. But it has not weakened the arm of public justice. Its equal and steady impartiality has soothed all the contending sects into the most harmonious equality. But to none of them has it yielded any of the rights of a well-organized government. That is all. Thank you, Your Honor.
Thank you, Mr. Gardner. Court is adjourned. We will reconvene in the morning for Mr. Sampson's reply.
Thank you, Your
Thank you
Honor.
very much, Your Honor. Thank you.